Good afternoon. I'm Amelia Reinhart. It's my privilege to serve as the Dean of the West Virginia University College of Law. It is my great pleasure to welcome you to today's celebration of Constitution Day. This day marks the anniversary of the signing of the Constitution by its drafters on September 17th, 1787, and it became an official holiday in 2004, thanks in part to the great bringer of things to West Virginia, the late Senator Robert C. Byrd. During his lifetime, the senator was the gift to West Virginia that never stopped giving. And today, from beyond the grave, Senator Byrd brings us the gift of Constitution Day. This year's program will provide a whirlwind tour, looking back some of the key constitutional law cases decided by the Supreme Court in the last term, and previewing a few of the cases coming up in the new term that starts next month. Our tour guides will be four members of our wonderful faculty, Professors Bob Bastras, Professor Ann LaFaso, Professor John Taylor, who all regularly teach constitutional law courses at our college, and they will be joined by Professor Larry Rosenberg, who directs our U.S. Supreme Court Clinic and is both a partner at Jones Day in D.C. and an experienced advocate before the U.S. Supreme Court. And take it away.
Great. Thank you so much, Amelia. Today we're going to be doing a U.S. Supreme Court review and preview. And we've divided up the cases. We're going to talk about 15 or 16 cases, so we're going to go through it fairly quickly. But first, what I'd like to do is thank the Dean for all of her support, James Jolly and Ken Price for what they do, which is unbelievable, and also Michael English, who did some research assistance at the last minute for this, which is we were very grateful for. As you can see, this is what our agenda is, and we're basically, I'm going to give a very brief introduction, and then we're going to do a review of the 2020 to 2021 term, and then we are going to give a preview of the 2021 to 2022 term. I will make these slides available to anyone who wants them. So just a brief introduction here is that about 50% of the decisions of the last term had an 8 or 9 vote majority, and that would have been higher and closer to a 57% had Justice Barrett participated in 12 cases that she didn't participate in, and Justice Alito had participated in a case that he recused himself in, or at least that's what we think. So that's a pretty high percentage of the cases that are nearly unanimous. Since 2006, no less than 40% of the decisions were 8 or 9 vote majorities. And I bring that to your attention because sometimes people think that the court is extremely political, and perhaps on the edges it is, and that's what we hear about often is the most controversial cases. Between 2020 and 2021, nearly 15% of the decisions had a 5-4 majority. So that's 15%. And since 2006, that has gone from a low of 12.3 to a high, which it was an unusual high, though, of 33.3%. And that's a spike. That's really an anomaly. So really close to around 20% usually are these 5-4 majorities. So those are your controversial cases. Just over 61% of the decisions had 7 or greater votes. What we're seeing is perhaps on the margins that the RBG-ACB switch makes a difference, and some lawyers are even calling the 6-3 the new 5-4, but we'll see whether that's true or not. The Chief Justice was on the losing side of many of the 5-4 majorities, and so we also see that sometimes justices, we think they're going to decide one way, and they surprise us as they mature on the bench. Justice Kavanaugh has the fewest dissents, which looks like he's becoming a little bit like Justice Kennedy, so how he served. And some thinkers are feeling that maybe we have a far right, a right center, and a left, with the left being, or even really a left center, Breyer, Kagan, and Sotomayor, the right center being Roberts, Kavanaugh, and Barrett, and then the far right being Thomas and Alito, maybe Gorsuch in between one of those. But with that, I'm going to turn this over to, I believe, we're going to start the next term in which our dear Justice Ginsburg passed away, and we are going to talk about Collins v. Yellen, which will be Professor Bastris.
Okay, so Collins presented several questions under the Housing and Economic Recovery Act of 2008, which Congress passed in response to the housing crisis of that year and the Great Recession. And it was among fears of the collapse of Fannie Mae and Freddie Mac, which are the two leading sources of mortgage financing in this country. In the statute, the Congress created the brand new agency, the Federal Housing Finance Agency, with power to regulate the mortgage market and to, if need be, step in as a conservator or receiver for either Fannie Mae or Freddie Mac or any other major mortgage financer. In establishing the new agency, Congress installed a single director head of the agency who could be removed by the president only, quote, for cause. And that was challenged as an unconstitutional limit on the president's powers, on the president's removal powers. Unlike the appointments power, there is no express textual basis for the removal power, but the Supreme Court has for quite some time now inferred the power from the structure, the unitary structure of Article 2 of the Constitution, and particularly Section 1 of that article, all executive power shall be vested in the president. So the Article 2 really creates a sort of pyramidal structure. And from that, the court has said in order to exercise his full authority, the president needs a removal power to control those under him. Beginning in the 1930s, the Supreme Court has, however, upheld limitations on the president's power of removal with regards to independent agencies, i.e. those that are created outside the structure of the executive branch, or at least sort of exist to the side. And the court has maintained a distinction between the president's power to control independent agencies versus his power to control executive agencies, the latter being complete, but with regards to independent agency, it's qualified. But in 2020, in other words, the preceding Supreme Court term, the court in a case called Seala Law versus Consumer Financing Protection Board refused to extend those cases limiting the president's removal power to the rather historically unprecedented creation of an agency led by a single director, that where a director has the full scope of that power. The court concluded that Congress could not impose a limitation on his power of removal. And in that case, the removal power was limited to certain specified grounds for removal. So the Recovery Act then limited the power to only for-cause removal of the director. The court quite quickly concluded that Seala Law controlled this case and that any distinctions between the two cases simply were not significant. The court noted that there was a difference in the nature and breadth of the two agencies involved, but that it was in some cases the Financing Board, the Recovery Act Board was actually broader. In some context, it was perhaps narrow. In any event, courts do not have the power to draw such distinctions based upon the relative breadth and scope of an agency's power. And more significantly, the court said the fact that the power in this case was perhaps limited in not as much as in Seala Law. Nevertheless, even modest restrictions on the power to remove a single agency head violate the separation of powers that the court of its doctrine that the court has created. And finally, the court held that the fact that sometimes the agency in question would act as a private party if it became a conservatorship, that's not all it does, and in any event, even when it's acting in that capacity, it's still subject to the strictures of the act. So all in all, the court concluded that seal of law controlled and that Congress cannot limit the power of the president to remove these single agency heads.
Thank you, Bob. We'll move on to Professor Taylor.
All right, thanks, Bob. Thank you, Ann. So there are a few con law topics that are even sexier than limits on the presidential removal power. One of those topics, sexy topics, is justiciability in general and standing in particular. While it was not the only standing case in the court's last term, California versus Texas was certainly the most high profile. So to run through it quickly, I'll begin at the beginning, which, as Mary Poppins tells us, is a very good place to start. As everyone knows, the individual mandate requiring most people to maintain minimum essential health coverage was a very controversial feature of the Affordable Care Act, aka Obamacare, right from the start. Challengers argued that Congress did not have the power to do this, and they almost won that argument in the Supreme Court in 2012 in the Sebelius case. The court held that Congress, in fact, lacked the power to impose the mandate under the Commerce Clause and the Necessary and Proper Clause, but in the end, Chief Justice Roberts sided with the four more liberal justices to uphold the mandate as an exercise of the taxing power. Fast forward a few years to the Trump administration. While Republican promises to completely repeal Obamacare did not come to pass, the Congress did zero out the penalty for failing to maintain minimum essential health coverage in the Trump tax cut bill of 2017. Now, the mandate remains on the books, but if you don't follow the mandate, nothing actually happens to you. You don't have to pay a tax or a penalty, so perhaps it would now be better to speak not of the individual mandate, but of the individual suggestion. So the arguments that culminated in Texas and California versus Texas went like this. Step one, Congress only had the power, according to the Supreme Court, to impose the individual mandate because it was a tax. Now it doesn't raise any money, so it can't be a tax, and therefore the individual mandate is unconstitutional. Step two, the individual mandate cannot be severed from the rest of the Affordable Care Act, and therefore the whole thing goes down in flames. And the conclusion, lo and behold, would be, what do you know, the entire Affordable Care Act, including the stuff that people like the guaranteed issue provision, is all disposed of by the unelected federal judiciary, and all the democratically responsive Republican Congress had to do to make that happen was to zero out one unpopular tax. As Republican politicians would say, a thing of beauty is a joy forever. Now, most law professors regarded this as pretty dubious, but the challengers handpicked a federal district judge in Texas who bought the whole thing hook, line, and sinker. I will skip past a mealy-mouthed decision from the Fifth Circuit to get to the Supreme Court. Now, in this case, and in every case, the Supreme Court, before reaching the merits, has to satisfy itself that the folks bringing the case have Article III standing. They have to show that they have suffered or will soon suffer a concrete and particularized injury that is fairly traceable to the government action and redressable by the courts. In short, they've got to show injury, in fact, causation, and redressability. So there were individual plaintiffs and state plaintiffs, and they had different theories. The individual plaintiffs said, my pocketbook has been injured. Why? Well, I bought health insurance that I wouldn't otherwise want because the government made me do so, made me in the sense of telling me I was required to do so even though it wouldn't do anything to me if I didn't. Okay? The court said, okay, pocketbook injury would be an actual concrete injury, but you can't trace that to the government when they didn't make you do it. Essentially, you brought that on yourselves, so you had no standing. The state challengers made two different arguments. First, they said, the mandate is going to mean more people opt into our state-operated insurance programs, and that's going to cost us money. Unsurprisingly, the court said there is no reason whatsoever to think that people who don't want health insurance will join your programs simply because an unenforceable mandate tells them to, so you've got nothing there. The states also said it costs us money to administer Obamacare, and we would be benefited if the whole thing was struck down. The court said, yes, but none of those costs are imposed on you by the provision it issued the individual mandate, so your concerns are not fairly traceable to the challenged government action either. Therefore, no one has standing and the case is gone. Justice Alito and Gorsuch dissented. Interestingly, Justice Thomas said in a concurrence, and I am paraphrasing here, he said essentially, I stand second to no one in my hatred of this law and my disdain for our court's former decisions upholding this law, but here, Justice Breyer is simply right that there's no standing, so that's it. So Obamacare, complete with the individual suggestion, still lives. Okay. The next case is also me, and this is going to be something of a challenge because I could talk about this for literally hours, meaning like even more than I talk about most things. So I'm going to try to cut to the chase. This is a free exercise case, and you have to have some background to understand it. So real quickly, the biggest question in free exercise law arises like this. Suppose you've got a general law that applies to everybody, like a compulsory school law that says everybody's got to send their kids to school until they're 16, or a drug law that says nobody can use controlled substances like peyote. Well, it turns out that these laws impose problems for some religious people. Maybe the Amish don't want to send their kids until they're 16 because that's going to undermine the community. Maybe Native Americans ingest peyote, right? What do we do in that situation? Specifically, should courts be empowered to grant judicial exemptions from general laws like this that were not passed for the purpose of burdening religion? Okay? Skipping to some relatively recent history, from about 1963 to 1990, the court answered that question, yeah, courts should grant exemptions here. And at least on paper, the court said the standard is strict scrutiny, which is supposed to be tough to meet. But in fact, during that period, religious challengers rarely won their cases. The court was kind of talking the talk of strict scrutiny, but not walking the walk, right? Then in 1990, the court decided Employment Division versus Smith, the peyote case, and what the court essentially said is, as long as the law is neutral and generally applicable, the First Amendment is not violated, no matter how much it burdens religious believers, no matter how tough it makes their lives. And in an opinion by Justice Scalia, which was basically 5-4 in the change in the law, his message was, courts have no place in the exemption business for neutral and generally applicable laws. If you are burdened by such a law, your recourse is to make your case to a legislature. Don't expect the courts to help you, okay? So skipping a couple things that are important but I don't have time for, I want to say this. Ever since Smith, lower courts have been debating how to read it. Some courts took Justice Scalia at face value and basically said we shouldn't be granting exemptions unless we think the law is straightforward religious discrimination. Other courts seized upon exceptions language in Smith and tried to make it as big as possible. The most important exceptions language is the question of what makes the law neutral and generally applicable. And as it turns out, the most influential lower court opinion reading Smith narrowly and making it hard for a law to qualify as, quote, neutral and generally applicable, was written by a then judge on the Third Circuit, Samuel Alito. And of course, we all know where he is now, okay? So ever since the 1990s, lower courts have kind of been talking and disagreeing with each other about how to read Smith, waiting for guidance from the Supreme Court, which has never come. But over time, pressure has built up to narrow Smith or to perhaps overrule it for two big reasons. One, the court has changed. It's become more conservative in a kind of pro-religion direction as opposed to a judicial restraint direction, which was more Scalia's thing, right? And second, our paradigm plaintiff has changed, right? In Smith and in the years before that, the paradigm plaintiff was, the Amish person, the Orthodox Jew, the Native American religionist. Relatively small groups where laws burdening their practices, the legislature probably wasn't thinking about them very much, right? But today, our paradigm plaintiff is the religious conservative who is now on the outside looking in of a new social consensus about sexuality norms, and in particular, norms recognizing the full equality of gay people, right? And so now that's really who the court is thinking about when it decides these cases, and that's resulted in a lot of polarization. Now, when we think about religious liberty, we think of it as kind of religious liberty versus gay rights, which divides people and has made liberals more interested in Smith. Okay, so cutting finally to the current term, what has happened? The bottom line is that over the past term of the Supreme Court, it's become clear that the permissive exception swallow the rule reading of Smith that Justice Alito championed has now become the law. This actually happened first in some of the so-called shadow docket pandemic cases, where after Justice Barrett came on the court in the wake of Justice Ginsburg's death, you had 2 5-4 decisions in which the court basically applied the reasoning that Alito had used on the Third Circuit and engaged in a searching inquiry to say, if the government has treated some secular or activities and entities more favorably than religion, we're going to take our own hard look at that and decide whether the government is correct in its judgment that the COVID risks of the religious activity are bigger than the COVID risks of the secular activity that is left alone. And in both cases, the courts, in both the Cuomo case and the Tandon case in California, the courts second-guessed the government. Finally, Fulton itself. This is a controversy about foster care. The city of Philadelphia for a long time has had an arrangement where to place foster children, there are private agencies that do screening. Catholic Social Services is one of those. Catholic Social Services would work with gay children, they'd work with individual gay people, but they wouldn't work with unmarried couples, whether they were straight or gay, and they would not work with couples in a same-sex marriage. If somebody in those categories came to CSS, they would have said, hey, here are 28 other foster care agencies in Philadelphia that you can work with, but in fact, nobody like that ever did come to CSS. Nonetheless, it became an issue in the press that CSS was not going to work with same-sex parents. Philadelphia took exception to that and kicked them out of the program, and CSS sued. Now, the legal issue here was that the city could point to what appeared to be neutral and generally applicable anti-discrimination ordinances that were guiding its action, and under Smith, that ought to have been okay. And indeed, the court seemed to recognize that Smith might mean that the city wins, because in the cert grant, they said, we're willing to talk about whether or not Smith should be overruled. It turns out that the court ruled 9-0 for Catholic Social Services and that they could be let back into the program, that the Free Exercise Clause required that, but they didn't overrule Smith. Instead, they said, nothing that Philadelphia relies upon as a generally applicable law will help it. In particular, there was a provision in the foster care contract, and it said, you cannot fail to work with families or children because of sexual orientation unless the commissioner gives you an exception. Had Philadelphia ever given anyone an exception? No. But the court said, doesn't matter that they haven't, doesn't matter that they won't, they could, it's in the text of the statute, therefore it's not a neutral and generally applicable law. That idea was in the jurisprudence, but this takes it to new height. The exception is broadened to where it essentially swallows the rule. So where are we now? Basically, we know that Smith has been considerably weakened, right? 3 justices, Alito, Gorsuch, and Thomas, said you didn't go far enough, you should have gotten rid of Smith altogether. So now we know Smith is being read much more weakly than probably Justice Scalia would have intended, and the question is, how much longer for this world is the Smith decision, and what will replace it? Okay. I'm out.
Great. We'll now hear from Professor Bastress.
Okay, I'm going to discuss 2 First Amendment cases. Well, let's put it this way, 2 cases that presented First Amendment issues. And the first one is a case that got a fair amount of public attention, the Mahanoy Area School District versus BL by and through Levy, BL being a juvenile, which therefore the court used her initials. BL had finished her freshman year in high school and tried out for the varsity cheerleading team. She was not selected for the cheerleading for the varsity, but she was allowed to participate at the junior varsity cheerleading squad. And as Justice Breyer, in his opinion for the court in this case, rather nicely put it, BL did not react gracefully to her rejection. So she then proceeded, BL, went with a friend to a local grocery store, I think, a convenience store, and posted two photos with her smartphone, posted two photos on Snapchat, which is, of course, a social media application that I know nothing about. And these two photos included one which was a picture of BL and a friend of hers with the caption of, and I quote, Justice Breyer, fuck school, fuck softball, fuck cheer, fuck everything. And this was a caption that was underneath a photo of the two girls posing with their middle fingers sticking up.
It's fair to say they were displeased.
Yes. And the second photo was just simply a caption which read, "Love how me," and this other student, "get told we need a year of JV before we make varsity, but that doesn't matter to anyone else, question mark." So this became a bit of a cause, these postings became a cause célèbre at the Mahanoy area high school, and it got back to the cheerleading coaches and the principal, who then decided that the use of the vulgar language and the criticism of the cheerleading coach was cause to suspend BL from cheerleading for a year. And of course, a lawsuit ensued. And the Supreme Court had on several occasions addressed the free speech rights of public school students, beginning with the Tinker case in 1967, noting that public school students do not shed their First Amendment rights at the schoolhouse door. But over time, the court has taken a much more lenient view of schools' abilities to discipline students for their speech. However, in each of those cases, the speech occurred within the school, or at least within a school activity. And this was the first case to come to the Supreme Court. Cases had bounced around in lower courts for some time, but this was the first case in which the offending speech occurred outside of school hours and off the school premises, and did not involve a school activity. So Justice Breyer, again, he writing for the court, distilled from the prior cases three categories of speech that the schools have been able to reach. One is speech that's indecent, lewd, or vulgar, referring to a case in which a student was disciplined for a nominating speech he made at an assembly, which included a lot of sexual double entendres. A second category in which speech had been perceived as advocating illegal drug use, a case in which the Supreme Court reached the improbable conclusion that a sign that said "bong hits for Jesus" promoted illegal drug use. It's an inexplicable decision. And then a third category in which the student's speech comes bearing the imprimatur of the school, and referring to a case in which students had published a school newspaper. And then, of course, the catch-all from the Tinker case, that any speech causing a material disruption of the school activities. So the court was not willing to reach the conclusion which the Third Circuit had, that the schools could not discipline student speech that is engaged in off the school premises and off the school time and not involving the school in any way. The court said there's all kinds of student speech that can affect, that the school has a perfectly legitimate right to be concerned about and to limit, such as harassment and bullying, direct threats to teachers or other students, and also all kinds of ways in which the school is in some way involved with external speech. So the court recognized that there could be a scope for school regulation of off-campus speech. But at the same time, there were three features that the court noted which perhaps limited the school to a much greater extent than it's limited in regulating on-campus speech, in which the courts basically say anything reasonable is fine. The first is that the schools do not stand in loco parentis under the common law doctrines when the student is not in their custody, so to speak. Second is that if the schools could regulate off-campus speech in the same way that it can regulate on-campus speech, when you put the two together, there'd hardly be anything left for the students to engage in. And of course, a lot of off-campus speech might be directed at matters of public concern, political events, and so on, which the school has no business in any event. And third, the court noted that the schools would actually be fostering healthy democratic expression if it allowed the students some reasonable degree of leeway in their off-campus speech. And so putting all that together, the court concluded that here the student was engaged in criticism. Granted, it was somewhat off-color in its tone and content, but nevertheless, it was legitimate speech, and certainly the court has provided protection to that very word that the student used in other contexts. So the students here, the court concluded, were acting in a manner which was entitled to First Amendment protection. The other case I want to refer to, at least, is the case was captioned when it was decided by the Supreme Court as Biden versus the First Amendment Institute at Columbia University, but the case actually was born with a suit against Donald Trump after Trump blocked a number of people who wanted access to his Twitter account, that he didn't want them participating in his Twitter forum. And so Trump was sued over that. And the Second Circuit said that it was, in fact, a violation of the First Amendment for Trump to try to block people from his Twitter account, because the Second Circuit said that Trump had essentially created a public forum with his use of Twitter for discussing official presidential business. But by the time it got to the Supreme Court, of course, Trump had lost, and the court then, when Biden was substituted in, concluded, not very controversially, concluded the case was moot. But there's a concurrence to the this denial of certiorari by Justice Thomas that I think is worth noting, pointing out the degree of difficulty of the issues in this case and how novel they are. And the main issue, of course, is whether the Twitter account can be a public forum under the court's doctrines. And if it's a public forum, the First Amendment kicks in. If it's not, then the First Amendment is essentially irrelevant. And Thomas noted, of course, the Second Circuit had found a public forum based essentially on the fact that Trump's use of it was governmental. But as Thomas points out, the control over Twitter was totally in the hands of private individuals. And in fact, Twitter eventually blocks Trump and denies him use of Twitter because of his abuse of it. And that was true of a couple other social media platforms as well. And so Thomas is raising the question about whether these can really be public forums if they're totally controlled by private entities. And then he points out the additional problem, which is, I think, the one that's most daunting for First Amendment advocates, is the fact that these social platforms are totally controlled by private individuals and can be wielded in very undemocratic fashion. And of course, Trump's subsequent litigation, when he sued Twitter and these other platforms for blocking him, raises these issues as well. And it seems to me it perhaps cries out for some legislative solution, because on the one hand, you have privately controlled media, but on the other hand, you have a concentration of power in private hands in ways which can have these anti-democratic effects. And we've been through this before when we had just 3 networks who had a sort of almost a monopolistic control over television news. And Congress's response to that was the Fairness Doctrine, which we've gotten rid of, and for good reasons. But still, there could be perhaps a congressional solution. And in fact, such has been advocated by the person who controls Twitter, and I'm forgetting his name at the moment, but the Zuckerberg, Mark Zuckerberg, has recognized that perhaps this is an area calling for legislative solution. But the free speech concerns, I think, are enormous, especially given the volume of expression that occurs on these platforms.
Thank you, Professor Bastros. I'm going to do 3 cases right now, fairly quickly. First is Bonta, that Chief Justice Roberts authored. It's a 6-3 decision. And in this case, the petitioners, which were tax-exempt charities, challenged a California law that had mandated disclosure of those charities' donors on their tax forms. The petitioners claimed that the law was unconstitutional on its face and as applied because compelled disclosure of petitioners' donors violated petitioners' First Amendment right to freedom of association. The court agreed, holding that the law was facially unconstitutional because the state could not justify the burden it placed on those associational rights. But significantly, the court did not agree on what standard of review to apply. Roberts, Kavanaugh, and Barrett endorsed an exacting standard for free association cases, which does not require that disclosure rules be the least restrictive means of achieving government ends, but does require that they be narrowly tailored to the government's asserted interest. Thomas endorsed strict scrutiny, and Gorsuch and Alito took a more fact-based approach, concluding that the state failed to meet either standard. In dissent, Sotomayor, Breyer, and Kagan criticized the majority for accepting without requiring petitioners to show an actual First Amendment burden. According to the dissent, the majority effectively allows regulated entities to avoid obligations by, quote, vaguely waving toward First Amendment privacy concerns. The upshot of this case is just what constitutes exacting scrutiny remains nebulous, and the court continues down the path of strengthening the First Amendment rights of institutional persons. In Cedar Point Nursery versus Hasid, which I want my labor law students to pay close attention to, this is a Roberts case. Roberts, Chief Justice wrote it. The Chief Justice wrote it. It's, again, a 6-3 decision. Here, a California law granting unions a right of access, which was up to 3 hours per day, 120 days per year, to an agricultural employer's property in order to solicit support for the union, is a per se physical taking under the 5th and 14th Amendments, thereby entitling the landowners to compensation. This case is important for several reasons. First, the court applied straightforward takings analysis rather than Penn Central's regulatory takings analysis. As Roberts explained, Penn Central does not apply when the government has physically taken property for itself or someone else by whatever means, or has instead restricted a property owner's ability to use his own property. Whenever a regulation results in a physical appropriation of property, a per se taking has occurred, and Penn Central has no place. Applying that analysis, the court held that the access regulation at issue here constituted a per se physical taking. Second, this case is a blow to public sector unions in California. It is always easier to organize employees at the workplace, and this decision makes workplace organizing more difficult. Significantly, employers have been long arguing that restrictions on their property rights created by state law constitute a taking, thereby triggering the Constitution. This is the first case to actually conclude that it is, which begs the question whether the court is headed down the road of federalizing certain property rights. Finally, in Brinovich versus the Democratic National Committee, written by Alito, but also another 6-3 decision, in this case, the court held that, that Arizona did not violate Section 2 of the Voting Rights Act when it first required in some counties that voters must vote in their assigned precinct, and 2, restricted the collection of mail-in ballots in bulk for submission. This case turned on the court's interpretation of 3 words in the Voting Rights Act: not equally open to participation by a racial minority, meaning that members of that class of citizens have, quote, less opportunity than others to participate in the political process and to elect representatives of their own choosing. In deciding that question, the court had to decide whether the state laws challengers had to show discriminatory purpose or discriminatory effect. Aligning along ideological lines, the court majority held that the mail-in ballot restriction was not adopted by the Arizona legislature with a discriminatory purpose. The dissent, in contrast, found a discriminatory impact on racial minorities, which was sufficient to have invalidated the Arizona law. Significantly, this case is the first to analyze time, place, and manner restrictions challenged under Section 2. Without committing to a bright-line test, the court outlined the key factors that it will use to determine whether facially neutral time, place, and manner restrictions violate Section 2, including the size of the burden when Section 2 was the size of the burden imposed, the degree to which a voting rule departs from what was standard practice when Section 2 was amended, the size of any disparities in a rule's impact on members of different racial or ethnic groups, the opportunities provided by a state's entire system of voting, and the strength of the state interests served by the challenged voting rights rules. Moreover, this case signals how the court might, in the future, view other out-of-precinct voting policies, early mail-in vote policies, and ballot collection laws that have a disparate impact on racial minorities. As we all know, that is a hot topic. We're now going to turn to the 2021 to 2022 term, and we have some really interesting and delightful things to talk about. I turn this over to Professor Taylor.
Okay, thank you, Ann. Okay, so Ann has shamed me not just by her beautiful PowerPoints, as she always does, but by her extremely scrupulous adherence to our pledge to keep our discussion short. A pledge to which I did not adhere very faithfully. I've got a couple of small-scale cases that I'll talk about if we have time, but Larry has the cases that I think people are probably more interested in the next term. So if Ann, if you could shift, I'm going to let Larry go ahead of me, and I'll say something at the end if I can. But I think folks will be more interested in Larry's cases than in mine. So
Okay,
take it
great.
away, Larry.
Great. Well, thank you so much. I'm slightly disturbed that there's a large gun on the first slide having to do with my cases. I'm not sure what kind of subliminal signal that is, but Ann, I'm sorry if I have wronged you at all. The first case is the New York State Rifle and Pistol Association versus Bruin, which is also known as the New York State Concealed Carry case. This is a case up for this term that is currently being briefed. And the issue is basically that New York State allows both state and in some cases local officials to carefully consider concealed carry permits. And they consider things like the purpose for which the applicant wants to conceal a handgun, the local nature of the area. Is it a high crime area? What's the profession of the applicant? Is this person, a private investigator, or does this person face danger? Almost all of the individuals who either testified or are involved in the case did in fact receive concealed carry permits, but they were limited. In other words, they were limited to certain areas or certain purposes or certain times, and they wanted unlimited concealed carry. And so the question that the Supreme Court is going to address is whether these state and local licensing requirements violate the Second Amendment. Now, I think it's important to note that while the Second Amendment, of course, has existed since the founding of our great nation, it has been interpreted by the courts as something less than absolute for most of its existence. And so these state and local restrictions have existed for quite a while. There have been various court challenges and various decisions, including the Heller case and a number of other famous Supreme Court decisions over the last 20 or 30 years. But nobody has really taken the position, I think, that gun rights are absolute and that every person is free to walk around with a concealed weapon. So there's a pretty lengthy history of having states and localities impose these kinds of restrictions. I think perhaps the most interesting issue, and it's one we're going to contrast with the abortion cases that are coming up, is the kind of constitutional analysis that is being done in the case. And so what you have are the left, the gun control folks, saying that there should be state and local nuanced individual regulation. And you're having the folks on the right, the gun lobby and others, saying that there should be an absolute Second Amendment right to bear firearms, including to conceal weapons in most, or at least many circumstances. And it's interesting to see that lineup. I also should mention, and probably should have done this at the beginning, that the cases I'm discussing are all cases that I've been involved with, either directly or indirectly, because I'm a member of the American Bar Association's Standing Committee on Amicus Curiae briefs, and the ABA has filed or will file amicus briefs in all of these cases. My observations about these cases should not be taken to reflect the position of the ABA, my law firm, Jones Day, the West Virginia University College of Law, and most especially Professor LaFaso. So anyway, this is going to be a very interesting case, and we'll see how it turns out. You go to the next one. So I'm going to talk briefly about a couple of criminal procedure cases that involve the Eighth Amendment and the Fifth and Sixth Amendment. And then we'll circle back to the abortion cases and contrast them with the gun cases. I wanted to talk for a minute about the US versus Tsarnaev case. You may remember a little event that happened a number of years ago called the Boston Marathon bombing. And Dzhokhar Tsarnaev and his brother were very likely, and most people, the evidence is overwhelming, were the people who perpetrated that. The older brother was killed in the ensuing activities. Tsarnaev wound up hiding out and was ultimately found by a drone and ultimately incapacitated and taken into custody. And I will note that while the Boston Marathon chase and search, and while Boston was on lockdown, I had the privilege of being in a board meeting with a number of former law enforcement officials, including the former director of the FBI, talking about all of the techniques that law enforcement was going to use to try to bring in Dzhokhar Tsarnaev alive, because they thought it was very important to sort of the law and order of the country to have this person brought in alive and ultimately tried in court. And so what happened was, the first thing that the defense did when it was approaching trial was they moved to change venue in the case, because they realized that everybody in the greater Boston area knew about the Boston Marathon bombing. They were all on lockdown. They were all personally affected. And they didn't think that Mr. Tsarnaev could get a fair trial in Boston. And I will say, if ever there was a case for a change in venue, it was this one. That motion was denied. After that motion was denied, the next thing the defense did was to say, well, look, there's been extensive pretrial publicity. We at least need to ask what are called content-specific questions to all of the prospective jurors about the pretrial publicity that they saw, how it may have affected their view of Mr. Tsarnaev, how it may have affected their view of the case. And shockingly, I think, the judge denied that. The judge only asked, or was permitted the lawyers to ask, very general and sort of just a few questions about pretrial publicity, and simply, said, did any pretrial publicity you saw affect you such that you couldn't render a fair and impartial verdict? And obviously the people selected for the jury said no. So this was something that I think really surprised the criminal defense community, the way this played out. Tsarnaev was, of course, found guilty, and I think there is relatively little question that he is guilty. But this went up on appeal to the First Circuit, and the First Circuit ruled that, in fact, the district court had erred, that these content-specific questions were essential in a case, particularly like this, that was so high profile, and it reversed the conviction and ordered a new trial. The government sought cert, and the Supreme Court granted cert. And the Supreme Court is now going to be tasked with deciding whether to reinstate the original conviction. And this is a really interesting case because I think it touches on the principle that even the most nefarious and likely culpable people entitled to the constitutional rights that we all share to a fair trial. And so the question is really not whether Tsarnaev is guilty. He is. But the question is, did he receive a fair trial? And should he receive a new trial given the errors in the prior trial? All right, Ann. I'll just briefly talk about another criminal procedure case that involves the right to counsel and the right to effective counsel, which is housed in both the Fifth and Sixth Amendments, and that is Shin versus Ramirez. This is an interesting case because there was a case from several years ago called Martinez versus Ryan that basically says that where there is an allegation of ineffective assistance of trial counsel, at least where this is raised on a habeas collateral challenge, there's a right to an evidentiary hearing so that evidence can be developed to show the trial counsel was ineffective. There's also a general rule under the Anti-Terrorism and Effective Death Penalty Act that you can't raise on federal habeas arguments that were not previously raised in state court. And so this conundrum develops where there is an ineffective assistance of trial counsel claim, but it wasn't raised on state habeas because the state habeas counsel was also ineffective. And so the question is, does the incompetence of state habeas counsel prevent the ineffective assistance of trial counsel claim from being heard on federal habeas? And so the question really is, should Martinez be extended to cover this circumstance? There are strong policy reasons to do that because, of course, the right that Martinez has conveyed can be useless if state habeas counsel doesn't raise the issue, and then that precludes the issue from being raised on federal habeas. However, in this case, the state has taken a rather interesting and aggressive position. They have said, no, you shouldn't allow this because this will encourage state habeas counsel to play games with the system and to intentionally not raise ineffective assistance of trial counsel claims in the hopes that you could then get a federal forum for those claims. The American Bar Association's amicus brief spends quite a lot of time addressing that issue because it is absurd. Number one, it is extremely hard to get a federal habeas review of the ineffective assistance of state trial counsel, even under Martinez. It is a very high bar. No sane attorney would ever give up the right for state habeas in the hopes that maybe some other attorney on federal habeas might be able to make the argument. It's simply an incredible argument, and I would note that the state does not cite a single example where this has ever happened in the history of the world. Moreover, there are disciplinary actions that could be taken against the state habeas counsel that intentionally fails to make a potentially winning argument. right? That lawyer could be disbarred, that lawyer could be sanctioned. And it seems incredible that any lawyer would risk him or herself in doing that. But that is one of the central arguments that the Supreme Court will address when it addresses this case. All right, Anne. So we're now going to conclude at least my section of this by talking about two abortion cases, both of which have been prominently in the headlines. The first is Dobbs, which is the Mississippi abortion case. This is a case where the state has promulgated a statute that says it is effectively illegal to get an abortion after 15 weeks of pregnancy. This runs right into the face of Roe versus Wade and its subsequent cases like Casey, which have basically said that prior to viability, the viability of the fetus outside the mother's womb, it is very difficult to impose significant restrictions on abortion. After viability, much easier, but before viability, much harder. And in Roe, viability was somewhat synonymously considered with the end of the second trimester, which would be about 28 weeks of pregnancy. Medical science has improved, and so now viability may be more like 22 to 26 weeks. And most cases have largely deferred to the medical profession as to what viability is, and it actually differs from pregnancy to pregnancy, but it's somewhere in that 22 to 26 week window. And Mississippi has taken this position that no, even these pre-viability abortions at 15 weeks or after 15 weeks should be illegal. And what is really at issue in Dobbs, and this is an interesting sort of trick of argumentation, in the cert petition, the state basically just said we should look at whether viability is itself the be-all and end-all, or maybe in some circumstances there could be pre-viability restrictions. In the merits briefing in the Supreme Court, the state has taken Roe head-on and said Roe must be overturned. And so the feeling has been that Dobbs isn't just about 15-week and later abortions, it's about overturning Roe and ultimately getting rid of all abortions. And so those are some of the stakes in the Dobbs case. And if you could go to the next slide. And of course, Dobbs exists side by side by the continuing saga of the Texas abortion case. And so we have Whole Women's Health versus Jackson. That is the matter that's already been up to the Supreme Court on the so-called shadow docket on a request for emergency relief. And in that case, Texas, of course, has this extremely creative and bizarre law that says that private citizens are empowered to sue individuals who facilitate any abortion that takes place after 6 weeks following a woman's last menstrual cycle. And so in most cases, women aren't sure or may not know at all if they're pregnant by 6 weeks after their last menstrual cycle. It effectively allows private citizens to attack almost all abortions that would take place in Texas. Because of this law, abortion providers like Planned Parenthood have decided to stop providing abortions, at least temporarily in Texas, after 6 weeks after the woman's last menstrual cycle. And so this has created great consternation. There was an immediate challenge to this on an emergency basis that went up to the Supreme Court. And the Supreme Court, in a 1.5-page ruling that came out a day after everybody thought the court would rule because the law went into effect. So they allowed the law to go into effect and then issued their ruling the following evening. Basically said, look, we're not going to address the merits. It did note, and I think this is important, that the challengers had raised significant legal issues about whether the Texas law is in fact legal and would likely stand on the merits. But the court said that it was very unclear whether the challengers in that case had standing, because there was no incident, there was no evidence that the law had actually been enforced by anyone. They also said that it was a particularly strange situation that they were asked to enjoin the actions of Texas state officials, including judges, when there's no state enforcement mechanism under the statute. And so you have this very creative law that, at least so far, has evaded a judicial review by the Supreme Court. Now, as you are probably aware, the Biden administration has filed suit challenging the Texas law. They have asked for a temporary restraining order of the Texas law. And I have not checked today, but it is eagerly anticipated that there will likely be a hearing on the government's temporary restraining order motion in the very near future. And so it may be that this law is ultimately enjoined and may work its way back up to the Supreme Court before the Supreme Court is able to address the Dobbs case on the merits. I want to conclude with one thought, which is to compare the arguments in the gun case to the arguments in the abortion case, right? So in the gun case, you have the folks on the left arguing that there should be state and local regulation, and the folks on the right saying there should be an absolute right. And of course, in the abortion cases, that analysis is inverted. You have the people on the left, the pro-abortion folks, saying there should be an absolute right to abortion or an almost absolute right to abortion pre-viability. And you have the folks on the right saying there should be a local, nuanced, and not consistent approach. And it's very interesting, given the two issues, how diametrically different the positions of folks who are, sympathetic to one side or the other are arguing. That may be explained by history, right? As I said, there has been a historical trend of less than absolute protection for the Second Amendment, and the rights to privacy that abortion are based on have been treated more or less more absolute over the last 48 years, at least since Roe. And maybe that explains it, but it'll be very interesting to see how all of this dovetails and comes out analytically in this court's term.
Do you want to do yours? Thank you, Larry.
Thank you, Larry. Yeah, we've got a couple classes starting at 1 here at the law school, and we said we'd keep it to 1, and we're a couple minutes earlier, so I think we'll wrap it there.
Okay.
I was going to talk about the Wilson versus Houston Community College, Carson versus Bacon, and the Ramirez versus Collier cases. In the unlikely event anybody's dying to know what I had to say about those cases, I'll be happy to send you my written notes. But with that, I think we will wrap it up. So whoever's out there, thank you for joining us. Thank you for the PowerPoints and the leadership, Ann. Thank you, Bob, who had to go to his class, and thank you, Larry.
And thank you, John, for your leadership in this.
All right, everybody,
you.
have a great day. Happy Constitution Day.